My name's Helen Westwood. I'm with the Professional Standards and Safety Unit of the Australian Services Union, our New South Wales and ACT branch. I wish to acknowledge that today I'm coming to you from the land of the Gadigal people of the Darug Nation, and I pay my respects to elders past and present. I particularly want to welcome and pay respects to First Nations people who are joining our webinar today, or our online briefing, I should say. Also, I want to acknowledge that wherever in Australia you're joining us from today, that you're also on Aboriginal land, always was and always will be Aboriginal land. So as I said, today's topic is about keeping our counselling confidential. We also know that it is a topic that could bring up very painful memories for some people, so we do want to give you that trigger warning. If this does raise issues for you, there are a number of services that you can contact for support. Of course, if you have a EAP through your work, please access that, or you could also contact the Full Stop Foundation Australia, and I'm going to put that telephone number in our chat box in a few moments, or the Men's Referral Service. And of course, if it does get too painful, please feel free to leave the webinar, and we will be happy to contact you later or speak with you later if that is of assistance to you. So today we are going to hear about the issue of sexual assault communication privilege. We want to know what it is. Some of you may already be aware, but we do want to talk about what it is and how it impacts victim survivors of sexual assault, and how it also affects the workers who support victim survivors of sexual assault. We also want to talk about what we at the ASU and as ASU members can do about bringing change, change that will be supportive of victim survivors and of you as workers who support victim survivors. So our guests today are Nina Funnell, Sam Parker, Angus McFarlane, and Karen Willis. And I've asked each of them to cover particular areas of this really important topic. And I'm going to start with Nina. Nina is a Walkley award-winning journalist, author, and sexual assault survivor advocate. Nina's work as a journalist, advocate, and campaigner has been, I know it's been recognised with a number of awards, and I'm sure probably many of you do as well, awards and honours indeed. Thank you so much for joining us today, Nina. Would you mind outlining what the issue of sexual assault communications privilege is, particularly in those matters before court? It'd also be really great if you wouldn't mind talking about the impact of this on victim survivors of sexual assault. Thank you, Nina.
Yeah, sure. Thank you, Helen. And I live and work on the land of the Gadigal people of the Eora Nation, and also want to pay my respects to elders past and present. So the campaign Don't Subpoena Our Support, Keep Counselling Confidential is really a collaboration between Unions New South Wales and a number of victim survivors as well as the media. And I just want to give you a little bit of context about that and then how that fits in with the sexual assault communications privilege. So the reason why we've decided, so the campaign is essentially to protect sexual assault counselling notes, so that when victim survivors go to counselling, they understand that that really is confidential. Most sexual assault survivors who go to counselling already assume, in fact, most members of the public assume that that material would be completely confidential. But of course, that's not always the case. If a matter does proceed to court, then the defence or indeed the prosecution or the police can subpoena that material. Now, there are avenues to try to object to that material being subpoenaed, but they aren't always successful, and often there is an incredible cost burden on the service or the individual psychologist, counsellor or practitioner to object to those notes being shared. The reason why we've done this campaign as a collaboration is because we recognise that when those notes are shared, it doesn't only impact on the victim survivors, it also impacts on the workers, and it can have a devastating morale impact on those workplaces too. So as a journalist, I've been working with a number of victim survivors from New South Wales who have had their sexual assault counselling notes shared, or subpoenaed, I should say, as part of the criminal justice process. And they've given me their consent to talk to their experiences, which I've published on. So one woman whose name is Jess Denham, Jess was sexually assaulted by both of her biological parents. Both of them were charged, and in 2016, the matter went to court and both parents were found guilty. However, as part of that process, 16 boxes of Jess's confidential counselling notes were subpoenaed. And when that happened, those notes were not only shared with the judge, they were actually shared with her pedophile offenders and their defence teams. Then when the trial was completed, those notes did not stay confidential as Jess had been promised inside the confines of the court. They were actually shared with the Australian newspaper, who used them as the basis for a podcast. And when that podcast was released, the podcast is called Shadow of Doubt. It had a horrendous impact on Jess's mental health. Very sadly, she made an attempt on her life. She's still with us and she gives consent to share this story because she wants people to understand the full impact of what that means when somebody's counselling notes are shared without their consent. The other thing that, of course, it did was it fundamentally undermined her confidence in counselling and in the confidentiality of the service. I also understand that it had a really horrific impact on her own therapists. As we know, this often does. I've heard therapists say things in the past like, maybe this person would have been better off if they never came and saw me in the first place. Another survivor who has gone public as part of the Keep Counselling Confidential campaign is a young woman called Madeline Lane. Madeline was sexually assaulted in New South Wales in April 2020. She reported to the police, but before she reported to the police, actually that night, immediately following the assault, she contacted 1-800-RESPECT and then she contacted Full Stop Australia. Now, the police made the decision to subpoena both 1-800-RESPECT and Full Stop Australia. Full Stop used the sexual assault communications privilege to object to their subpoena and they were successful. They did not hand over anything about that contact. 1-800-RESPECT very unfortunately handed over not only the counselling notes, but her entire conversation that she had had with 1-800-RESPECT in the hour immediately following her assault. Horrendously, that was then shared with the defence, and Madeline was made to read out verbatim her contact with 1-800-RESPECT when she was on the stand being cross-examined. The impacts of that on Maddie were, again, incredibly traumatic. Obviously, it's undermined her confidence in 1-800-RESPECT, but also it was deeply humiliating. And of course, in that moment following sexual assault, she was saying things like she thought it was her fault, that she was to blame. These things are obviously not uncommon. They're common trauma symptoms following sexual violence. That was used against her on the stand to try to discredit her. Since then, I've done a Freedom of Information investigation to find out how often 1-800-RESPECT is being subpoenaed. And the answer has come back through FOI that it's on average once a week, every week. And not only have they been handing over confidential counselling notes, they've actually been handing over audio recordings or video recordings in the case of video counselling. Another survivor who I've spoken to, Sarah Rosenberg, she's also from New South Wales. Her offender also subpoenaed a copy of her Medicare records, and through that got a complete list of every doctor, GP, counsellor, psychologist, psychiatrist she had ever seen, and then sent a scattergun of subpoenas to all of them. Through that information, they then managed to get, every blood test, every medical record you could possibly think of. But they also managed to get not only her sexual assault counselling notes, but her counselling notes going all the way back to a high school counsellor she'd seen for unrelated schoolyard bullying. And that was all dragged out in a courtroom to try to discredit Sarah. By using the fact that she visited a psychiatrist was used to suggest, oh, well, you must be psychiatric, therefore, playing into those age-old tropes about mental health and women being hysterical in order to try to discredit her in front of the jury. another survivor who is currently using a pseudonym, but she contacted police, reported her sexual assault. Her offender was charged, but police then advised her that she should not access any counselling or support whatsoever until after the criminal trial was over. In her case, that was 2 years without any sort of counselling or support whatsoever. And the reason why the police gave that advice, they were trying to be well-intentioned, but what they were saying was, we can't guarantee that the notes will remain protected. Then there's my own case, which I'll just touch on briefly. I won't go into a lot of detail because I'm conscious of people's own trauma histories, but my offender was a stranger. And when I was 23, I was sexually assaulted. I went to Royal North Shore Sexual Assault Counselling Service in the aftermath, and they were fantastic. The police at the time did not have a suspect, but they now do have his DNA, and with advancements with DNA technology, there is increasing chance that he could be apprehended, identified and apprehended, I should say. And were that now to take place, it's occurred to me that I now have 20 years of counselling notes that could possibly be subpoenaed. And I've talked about all kinds of sensitive things over the last 2 decades in my counselling. And unfortunately, this is a situation that survivors are now facing if they're at that point of going on the cusp of going to court, of having to choose between access to justice and keeping the community safe, versus but sacrificing their own privacy and confidentiality with their counselling in the process, or protecting themselves and the confidentiality of their counselling, but then not pursuing traditional criminal justice. So one of the things that we've been talking about with MPs during this campaign is the fact that if a sexual assault survivor goes to a lawyer, that's a privileged conversation. If they go to a priest or a religious leader, that's a privileged conversation. Even if they come and speak to me as a journalist, I can invoke media shield laws to try to resist a subpoena. But if they go to a counsellor, those notes can potentially be subpoenaed under the sexual assault communications privilege. And if the judge decides that there is either substantive probative value, public interest, or that the information could not be obtained anywhere else, they can grant that subpoena. And if they do, that can obviously have devastating impacts, not just on that victim survivor, but also on the counsellor in terms of their own psychosocial wellbeing, but morale, but also financially on them as well, or on the service. So this is why we are now calling as a collective, which, as I mentioned, it is Unions New South Wales in collaboration with victim survivors. We're also partnering with a human rights law firm, Mark Lawyers, who are helping on some of the legal work, as well as an organisation called Rape and Sexual Assault Research and Advocacy, which is also giving some support, to call on the New South Wales government to introduce an absolute privilege, so that confidential really does mean confidential, and there's just no ifs, no buts. When someone walks into a counselling room or a therapeutic space and they say, what's said in these 4 walls stays in these 4 walls, that is an absolute statement of fact, and there is no way possible that an offender or a room full of strangers will ever be able to effectively eavesdrop in on that conversation or be able to access it. So that's the background of the campaign. We're really encouraging people to sign and share the petition. And yeah, I will hand back to Helen, but thank you for coming today and for listening.
Thank you so much, Mina. It was, I think, a really good description of what the actual issue is, because for many who are not working in the sector, or maybe are new to the sector, maybe the first time that they would come up against the issue is when they receive a subpoena. So I think it is really important that we have that really detailed description of what it is and what the options are. And we have included the link that you've provided to Legal Aid New South Wales for assistance should anyone receive a subpoena. So thank you for that. Now, the other thing that I wanted to also do is I'm going to post some other information as well in the chat box, particularly around if you have a story, or if you have some information that you did want to share with Nina, anonymously or otherwise. I'm going to post that in there as well. But I'll do that when we're hearing from some of our other panellists. Sam Parker, if I could speak with you now. Now, Sam is a worker with a long, I always regret saying this, decades experience, because I know what it infers when we say things like that. But what I should say is Sam's a very experienced worker in the community sector, and particularly in women's services, working with victim survivors of family domestic violence and sexual assault. Sam is also now one of our colleagues here at the ASU as one of our organisers, particularly with women's services. And in that role, of course, Sam, you're speaking to many ASU members who work in women's services, who are counsellors, and who are also providing support services to victim survivors. So it'd be really interesting to hear your perspective on the impact of sexual assault communications privilege on victim survivors that you've worked with, but also other workers. So over to you now, Sam. Thank you.
Thanks, Helen. Hi, everyone. It's lovely to be here today. I'm here in the Penrith office, the ASU office, which is on Darug Land. So I want to acknowledge elders past and present and pay my respects. And to thank you all for having the opportunity to talk today. As Helen said, I'm lucky enough I kind of get to wear two hats. I'm an organiser at the ASU supporting members working in women's services, but I've also been working in the sector since the mid-90s, and I've had over 10 years experience working in women's health services, largely in the family and domestic violence space. And as we know, sexual assault does occur in family violence. In fact, it's prevalent in family violence. So I just wanted to touch a little on how it impacts workers. The first thing to acknowledge is that for our members working in the NGO space, workers are seeing some of the most vulnerable women in the community who may have a history of having been traumatised by systems. You know, when we look at child protection systems and health systems and other systems, there can be a huge amount of trauma, and women are choosing to engage with their local grassroots women's organisation because they feel that they are going to not be judged, they're going to be listened, they're going to be heard, and that they trust the workers. And that is key. For a counsellor meeting someone coming in for the first time, they can't possibly know what is going to be shared. We know working in the sector, there are legislative requirements where workers sometimes do have to share information. So we can, refer to 16A, where a child is at risk of serious harm. There's, as mandatory reporters, there's a requirement to report, but workers can have these conversations with the people they support in a way that is transparent and upfront. The same with Part 13A of the Crimes Act now around people who are deemed to be at serious threat. There's legislative requirements, but again, if you're a family and domestic violence worker and someone's referred, you know they've experienced family and domestic violence. That's why they're being referred. So you can, again, be having these open and frank conversations with women, which in fact build trust between the worker and the person they're supporting. But as a counsellor, it would be highly inappropriate to be setting someone up to be scared or afraid by saying at the very beginning, hey, there's a risk these files might be subpoenaed if you are talking about any kind of sexual assault matter. Like, it's just simply not appropriate. It's not trauma informed. It's not what you want to do. But what that does mean for workers is that they're supporting really vulnerable people and taking therapeutic notes throughout the session that are meant to support the process, to record kind of the strategies that are being explored with the person about what might be helpful. And it also notes some of the experiences the person has had. But the purpose of the notes is not for it to be a series of, facts that can be used in a court process. It's simply to guide the worker through the process. And especially if you're working as a team, you might not be the only worker needing to refer to those notes to provide appropriate support to the person seeking assistance. Now, for the worker who is aware or who has had an experience in the past of having their notes subpoenaed, that can create real tension, real stress. You're wanting to provide the very best support. You're wanting to record notes accurately in a way that feels appropriate, but you're also mindful of the fact that anything you record could potentially be subpoenaed and not only be read by other people, but the notes could actually be used in a way as a weapon against the person that you're trying to support. Now, as unionists, we are always mindful of the fact that workers have a right to be safe at work. We know that the work that you do in the sector places you at, a higher risk of experiencing things like vicarious trauma just simply due to the nature of the work that you do, the fact that you hear a lot of distressing information regularly, and then holding this additional stress about, gosh, my notes have been subpoenaed. I'm really worried that I might not have done the best thing by my client. And as Nina had referred to, there are, the sexual assault communication privilege. It's very complex. There's lots of issues with it. Not all workers know about it. And really the only way to keep these notes safe is to apply an absolute privilege so that all of the things that Nina's touched on and I've touched on are just simply not an issue moving forward. Thanks, Helen.
So much, Sam. That was, I think, really helpful to be able to understand the impact of the issue from a worker's perspective and how it can affect their work and the way that they practice their work. I also just wanted to remind all of our attendees, I did put this in the chat box, but just to remind you that we are recording today's webinar, today's session, and we have done that, of course, with our panelists' permission and with the permission of those women whose stories Nina has shared with us. Of course, as she said, she has their permission. So we will be posting this webinar to our ASU website probably in the middle of next week, I would say, but it will be posted. So if you've got colleagues that you wanted to share this session with, you can do that once we do post that recording. So our next panelist is someone who I think probably doesn't need an introduction to our ASU members, but is, of course, our New South Wales ACT Branch Secretary, Angus McFarlane. And I wanted to ask Angus if he could talk to us about the impact on, or his awareness of the impact of this issue on ASU members and what the ASU is planning to do to bring about reform, and what is the ASU's position on the whole issue. Thank you, Angus.
Thank you so much, Helen, and it's a great honour to be joining this panel of wonderful women's advocates and activists today to talk about this really important issue. I'm on Gadigal land in Redfern with Helen at our headquarters in Sydney. Look, I'll just be really brief, but I think there are a couple of reasons why it's obvious that the ASU would be really supporting this. The first one is the fact that many of our members are victim survivors, and this is something that would impact them and could impact, and may have already impacted them or could impact them in the future. And so we like to say as unionists, we support someone's whole life, not just around what's happening at work, but for people to have dignity and respect in all features of their life and well-being. So it's about supporting women first and foremost. The second issue, though, is obviously we're the union for counsellors, for sexual assault counsellors, for family domestic violence workers, for broader women's services workers in the NGO space. And as Sam has so well articulated, it's a workers' issue for our members as well, because these laws and the use of the subpoenas put our members in really difficult ethical situations that can create their own stress and psychosocial hazards, frankly, for frontline workers who want to provide the best therapeutic supports possible, but also are aware of risks of putting certain things in notes that then might actually potentially compromise the therapeutic care, and particularly if it's something where there's a team supporting people. And in some instances, our members wouldn't even know because the subpoena is issued to an organisation. So our members also don't have any consent or say about these files being handed over and may not even know it's happened. So that creates a lot of stress for our members who wouldn't want the support they're doing to somehow inadvertently end up further damaging someone or being used against them. The third reason is because we are the broadest union for the sector. And so we have a really proud history of campaigning for support for women, for better outcomes across the board, for tackling this family and domestic violence, for ending sexual assault. That is a part of our social justice roots and principles as the sector for women's services and the broader community services sector. So that's why we have partnered with Unions New South Wales, with NINA, with other victim survivors, with all the other sort of people that are coming together on this, because to us it's a no-brainer and something that we want to be part of actively supporting. We are the union that led the campaign for family domestic violence leave and brought many groups together to achieve that. That was a long, nearly 10-year campaign, but we got there in the end. We were the union that's supporting right now the calls for the sector for increased funding, for better resourcing to meet the demand and the need. We've campaigned for a long time to end the provision of for-profit providers in this space. And, you know, we were fully, I recall in particular the campaign to stop 1-800 Respect being privatised essentially by Christian Porter. And while that did end up happening, our position as a union is still remaining to this day that those services should not be run for profit, and they should be run by women for women, and that continues. So that's why we're supporting this campaign. And I guess I mention those other things because we stand on the shoulder of giants, and in our union, we never give up. We persevere, we keep going, we build great alliances and support across society and the sector, and ultimately we do generally win everything. It can take time though, and perseverance, but don't stand in the way of determined ASU women, I would say. And I have a lot of faith that we will get there on this because we're being led and guided by such outstanding advocates. And I know it's something so important to ASU members. So, and we have discussed it with our women's services sector members and formally sort of endorsed the campaign. And I look forward to doing whatever we can to continue to support it. Thanks, Helen.
Angus. Well, speaking of determined ASU women, just before I go to one of those determined ASU women as our next panellist, I just also want to remind all of our attendees that you're welcome to put questions in the Q&A option or function, which is, as I discovered today, behind the More button. But I know we've already got one question, so I want to let you know that we actually have allowed some time towards the end of our session for questions. So we will definitely get to that one question that we have there. And if there are any others, please feel free to post them. So as I said, Angus did talk about determined ASU women, and Karen Willis is certainly one of those. Karen is the Gender Equity Officer at Unions New South Wales, and Karen has a very long history in women's services, community sector. Indeed, not. I know she didn't actually begin in women's services, but there's certainly where she has spent probably the last couple of decades, I think it's fair to say, in the community sector, has been in a number of roles supporting women and specifically in family, domestic violence and sexual assault services. I've asked Karen if she can talk to us about the campaign. Campaigning is something that I think is a lifelong practice of Karen's, and this is a really important campaign that Karen is working with other great advocates on, particularly Nina. So Karen, if you could tell us about the campaign, where it's at to, what you've been doing, and what are ways in which ASU members can support this campaign.
Thank you very much, Helen, and hello to everybody. I'm in the wonderful Wollongong, so I'm not exactly sure whose land I'm on, but I do acknowledge that I am on Aboriginal land and I pay my respects to elders past and present. In the March Trades and Labour Council meeting, and anyone who doesn't attend Trades and Labour Council meetings, join up because we always have great speakers. At the March Trades and Labour Council meeting, we heard from Nina, we heard from Jess, who Nina talked about, who was the young woman who had her file subpoenaed and then not only used against her in court, but also used by in an appalling way by the Australian newspaper. And we also heard from Jan Primrose from our wonderful ASU. And what they all talked about was the need for absolute privilege in sexual assault communications. At the end of their presentations, our secretary, Mark Morey, got up and moved a motion in support of the campaign. There was an absolutely outstanding every response from the rest of the room. People were on their feet, people were clapping, and people were saying, we've got to get this done. So the Unions New South Wales and its 47 affiliated unions are 100% behind this campaign. We're also really excited that the ASU wanted to partner with us in that campaign for the reasons that Angus has already pointed out. So this is it's not going to be a 5-minute job, but we're absolutely determined to get it there. So what we've been doing so far is certainly gathering information, and as Nina said, Mark lawyers have provided us with some legal background and illegal information, putting information together. We've met with quite a lot of MPs in the New South Wales Parliament to say that we need to have this in place. We've also met with the New South Wales Attorney General. We know that the New South Wales Attorney General has made moves to begin to look at this issue, at what would be needed to be done, what areas of law reform will be required, if there's any unintended consequences. Our assumption will be that once he's put that together, there will be some sort of consultation process and then hopefully leading to legislation. We are very keen for this to be done before the end of this year because, as you know, next year we go into election mode, and that will put the whole process off for another year, which is just way too long for far too many people who will experience this systems abuse that's becoming more and more common in our courts when women make a complaint of sexual assault. We also have a range. We've got the petition, which Helen has popped the link to that in there. We're nearly up to 13,000. We want to get that to 50,000. So please sign that petition and pass it on and encourage others in your workplace and anywhere else you might go to sign that petition. That petition will also link you to a page on the Unions New South Wales website where all of Nina's articles are, and there's a range of other pieces of information and so on as well about the campaign, where it's up to, what communications privilege is, what we need changed, and how it needs to happen. By signing the signing the petition, I should say, we'll also, of course, we'll have your details. So we'll be letting you know about things next. So there might be some letter writing to MPs, encouraging people to go and visit their local MPs to talk about the issue. And there very likely will be other meetings and activities over the next few months. The ASU is going to be sponsoring a roundtable in Parliament House with people who are here, but also those who've experienced this sort of systems abuse in their court matters, as well as other practitioners. We haven't really figured out who will be on that yet, but we're working on that. And of course, we would be more than happy to hear about any counsellors who've had the experience of being subpoenaed, and you can contact Nina on that. Look, bottom line is that this concept of systems abuse only occurs in sexual assault matters. There's no other law where no other area of law where people's counselling notes are subpoenaed. And the only reason behind it is to use those counselling notes to undermine, humiliate, intimidate, and abuse those who've experienced sexual violence. They've already had enough. And now they're trying to seek justice, and then they cop this in courts. It's absolute systems abuse. We also have to look at it through the eyes of a gendered lens. It's, as we know, while men absolutely experience sexual assault, it is overwhelmingly a crime experienced by women. And the concept behind it is that women lie and women make up stories. And so defence lawyers need to undermine and humiliate and break them down to try and prove the innocence of their complainants. We have a less than 2% conviction rate in sexual assault in this country. It's just appalling the way we treat those who are brave enough to come forward. There's many other things that need to change in our legal systems and in our courts when it comes to sexual assault. This is not the only thing by a long shot. But at least we can do this one. At least we can stop people's private conversations with their counsellors where they're seeking to move to recovery after sexual violence from being used against them in court. I really encourage you to sign the petition and take whatever other actions we can do along the way. Thanks very much for your time.
Thanks so much for that, Karen. Nina, I know that you touched on this before, but I think just after hearing Karen speak, it might be really worth outlining again if there are other groups and other professions who actually do have absolute privilege.
Yeah, sure. And thank you to all the speakers. So there are some professions that do have absolute privilege. So if a survivor goes to their lawyer, that's a privileged conversation. If they go to a religious leader, a priest, for example, that is a privileged conversation. One of the reasons why we're really proud to partner with ASU and Unions New South Wales on this is because I think it's really powerful. Like, we know that survivors want that conversation with their counsellors and support therapists and psychologists, people in a support role, to be completely privileged. They assume it is already in many cases. And so they are absolutely gutted to find out that that has then been shared with third parties if a subpoena is placed. I was saying, I think, one of the reasons why I'm really proud to have the ASU involved in this campaign is because it sends a really clear message to our victim survivor community. And that is that change and reform is not just on their backs alone. Often when I've done campaigns in the past, like I did the Let Her Speak campaign to overhaul sexual assault victim gag laws in Tasmania, the Northern Territory and Tasmania. And when we were doing that, it often felt like it was on the backs of survivors to advocate for change. And I think that when we see the ASU, Unions New South Wales and other unions coming together, it sends a really powerful message to all the survivors, not just those in the campaign who are speaking out, but those in the wider community, that unions have their back and that the people that are providing that support and care within their own private lives are also symbolically aligned with this cause. I also think it's really strategic with government to be able to talk about, yes, this is impacting on victim survivors, but let's be mindful it's impacting on workers as well. It's impacting on their well-being, but it's also impacting on their capacity to do their jobs. And I guess the other thing I should say is that one of the things that I've heard a number of times now is that victim survivors really aren't aware of how those notes could actually be weaponized against them. In fact, the common assumption is, well, wouldn't my notes help? Surely it would help. The fact that I went to a service, that I sought counselling, the fact that I disclosed this, wouldn't that work in my favour in front of a jury? So sometimes what's happened, and the reason why they think that is because they think that juries will go, oh, you've suffered all these trauma impacts, you poor thing, not realising that actually in the hands of a skilled defence barrister, they can manipulate that and say, oh, you've had nightmares and flashbacks, so you've had intrusive thoughts, so you can't really tell the difference between fact and fiction. You don't really have a firm grasp on reality. You've got foggy thinking, you've got, and they can really manipulate and twist this, what we know are common trauma symptoms. So one of the things that we know is happening is that police are actually asking, in some cases, victim survivors to waive what few rights they do have, including the sexual assault communications privilege. And one of the survivors I've interviewed has talked about when you are in a police investigation, the power difference that's already present there, your fear that the investigation won't proceed unless you sign this waiver and you behave like a good victim means that they feel that there is no other alternative than to waive that privilege. So if you are a worker and you do ever receive a subpoena, even if it looks like the client has waived privilege, it's always worth checking in with them because often they might have waived it under duress. They also have rights. And there are mechanisms that, as I said, there is no absolute privilege here, but there are still some mechanisms that can be used to at least try to have a fight. But really, yeah, we need the absolute privilege. Thanks, Helen.
Thank you, Nina. So the question that we have is whether or not this is also happening in the ACT. Is this an issue in the ACT? And if so, is this campaign also happening there?
I can handle that one.
Thank you, Nina.
The short answer is yes, it is happening in the ACT. It is happening everywhere. The only place so Tasmania has a better version than certainly the New South Wales or the ACT. Recently, Victoria has announced an intention to introduce an absolute privilege. We are focusing our efforts to start with on the New South Wales government for a number of reasons, but the full intention is to then expand across the whole country. We're hoping to get traction in New South Wales, and then the idea would be that we will tackle all the states and territories as well as federally.
Right, thanks. And I noticed too, now I'm not sure whether Nina or Karen want to comment on this, but I did notice on one of the stories on the campaign webpage is about a worker at ACT, in the ACT at Canberra Rape Crisis Centre, I understand. Do you want to highlight that story, either Karen or Nina? Thanks, Nina. You've got your microphone.
All right, I'll jump in.
Please.
Yes, the amazing Canberra Rape Crisis Centre in 1997 received their first ever subpoena, and the manager of the service, Diane Lucas, at the time, realised that if she complied with that subpoena and handed over one of their clients' files, not only would that one client potentially lose faith and confidence in the service, but potentially all of their clients would. So Di went to court and essentially said, over my dead body, I'm not handing over this client's file. You can throw me in jail. And that's exactly what the judge did. So Di actually went to jail to protect the privacy of that client, and those client notes were actually never handed over. By the time she came out of jail, obviously this had started a national discussion. People were outraged that a manager of a rape crisis service could be imprisoned for protecting what many in the public just assume should be protected. This really doesn't pass the pub test. And so because of her activism, and as Angus said so eloquently before, we stand on the shoulders of giants in all activism that we do, and Di is certainly one of the many giants in this fight, whose shoulders that we stand on, and we build on that previous advocacy. Because of that advocacy, the first protections were introduced, the sexual assault communications privilege. Since then, there have been a number of iterations over the years, but of course, defence barristers will find loopholes, they'll find ways around things, and they will water down legislation when they get the opportunity to, those lobby groups. So we're now at the position of, while certainly things were moved forward because of Di Lucas's advocacy and the advocacy of many who come before us, we now need to build on that work and really see it through to completion this time.
Absolutely. Thank you so much, Janelle. I think that is a really good story to end on, because it does remind us about the need, and I know it is what we do in this sector. We do advocate, we do demand reform, and as I think all of our panellists have said today, we continue that fight until we actually get the result that we want and that our communities need. So please sign the petition. You will see the webpage there on Unions New South Wales, which is outlining the campaign, and a number of the stories that Nina has referred to, as well as others, are on that page. And at the ASU, we will continue to update you on other campaign activities. So if I can thank all of our panellists today, Nina Funnell, Karen Willis, Angus McFarlane and Sam Parker, and thank you to all of our ASU members for joining us online, and hope you enjoy the rest of your afternoon. Thank you, everyone. Bye for now.